Welcome to my channel, where we dive deep into the world of law. Whether you're a law student, bar reviewee, legal practitioner, or just someone looking to better understand the law, you're in the right place. Remember, ignorance of the law excuses no one from compliance therewith. Make sure to subscribe, like this video, and hit the notification bell so you never miss out on our latest legal insights. In the case Republic of the Philippines versus Manalo, GR number 221029, April 24, 2018, the Supreme Court addressed a significant issue regarding the application of Article 26 of the Family Code to a divorce obtained abroad by a Filipino spouse. Marelyn Tanedo Manalo, a Filipino citizen, married a Japanese national. After some time, Manalo obtained a divorce in Japan, which legally ended her marriage under Japanese law. Seeking to have the divorce recognized in the Philippines, Manalo filed a petition to cancel the entry of her marriage in the Civil Registry of San Juan, Metro Manila. The documents she submitted included the Japanese divorce decree, the certificate of marriage, and the authentication from the Philippine consulate in Japan. The Office of the Solicitor General, representing the Republic of the Philippines, did not present any evidence to counter her claims. However, the trial court denied Manalo's petition, ruling that under Article 15 of the Civil Code, Philippine law does not recognize divorce for Filipino citizens, whether they are married to Filipinos or foreigners. As such, the trial court held that Manalo's divorce was not valid under Philippine law. The central issue before the Supreme Court was whether a marriage between a Filipino and a foreigner, dissolved through a divorce obtained abroad by the Filipino spouse, could be recognized under Philippine law, allowing the Filipino spouse to remarry. The Supreme Court ruled in favor of Manalo, focusing on the proper interpretation of Article 26 of the Family Code. Article 26 states that if a valid marriage between a Filipino and a foreigner is celebrated, and a divorce is subsequently obtained abroad by the foreign spouse, the Filipino spouse shall have the capacity to remarry under Philippine law. The court clarified that Article 26 applies even if the Filipino spouse is the one who initiates and obtains the divorce abroad. The key consideration is that the foreign spouse is no longer considered married under their national law, which should equally allow the Filipino spouse the capacity to remarry. The court emphasized that Article 26 serves as an exception to the nationality principle under Article 15 of the Civil Code, which generally mandates that Filipino citizens are bound by Philippine laws wherever they are. The Supreme Court recognized that strict adherence to the nationality principle would lead to unjust discrimination against Filipino citizens married to foreigners, particularly in cases where the foreign spouse is free to remarry, while the Filipino spouse is not. Despite ruling in favor of Manalo, the court remanded the case to the trial court for further proceedings. Specifically, the lower court was instructed to determine and prove the existence and validity of the Japanese divorce law under which the divorce was obtained. This step was necessary because, under Philippine law, a foreign divorce decree must be proven in court, including the foreign law that allows it, to ensure that it is valid and applicable. This ruling is a landmark decision that underscores the protection of the rights of Filipino citizens in marriages with foreigners. It acknowledges the evolving nature of international family law and ensures that Filipinos are not unduly disadvantaged in mixed-nationality marriages. Thanks so much for watching. I hope you enjoyed the video. If you want to see more, stay tuned for the upcoming content. And if you're new here, don't forget to hit that like button and subscribe to the channel. I've got plenty more in store that you won't want to miss. See you in the next one.